Perfect. Thank you. Good afternoon and welcome to Grand Rounds. I'm Kelly Forrest, an attorney in the Central Florida Collaborative Practice Group and one of the co-chairs of the FACP Outreach Committee. We're pleased to present the November session of Grand Rounds, a monthly lunchtime training showcasing a different Florida collaborative practice group each month. The first portion of the session today will be a group presentation, and the balance will be a discussion period where we'll troubleshoot and brainstorm solutions to the unique problems presented in the session. If you have questions during the presentation, please place them in the chat and we will kick off the discussion period with them. Once the Q&A session begins, please raise your hand by clicking at the bottom of your screen in the reactions box when you would like to speak. For this session, the presenters have selected the topic, but we welcome ideas for future sessions. You can email ideas to us with a short fact pattern to me or to my co-chair, Liz Riveredo, and I will place our email addresses in the chat. Just so you know, I know some of you have registered for the full year. There will not be a Grand Rounds in December since it falls so close to the Christmas holiday. Our January session will be held on January 21st, and we will certainly, announce when we have the topic. Thank you all for coming, and I'm happy now to introduce the presenters from the Panama City Practice Group, Collaborative Divorce Professionals. Kim Reed is the collaborative family law attorney in Panama City who is licensed to practice in Florida, Maryland, and Washington, D.C. She's a director on the board of FACP and is the president of her practice group. Kim is also a Supreme Court certified family mediator. Welcome, Kim.
Hi, glad to be here.
Dr. Neda Koehnemann is a Florida licensed psychologist and a child custody evaluator. She has been performing forensic evaluations for 25 years and is a collaborative mental health professional. In her private practice, she works with children, adolescents, and adults. David Smith has many, many letters after his name on the presenter bio, and I don't know what any of them mean, but I did recognize retired Lieutenant Colonel, U.S. Air Force. He's also a collaborative financial neutral and a holistic financial advisor who enjoys working with military clients, and the perfect choice for this topic, the military divorce. Thanks to our presenters for taking the time and the effort to bring us this presentation. And now I will turn it over to Kim Reed.
Hello, everyone. We're going to start by reviewing the fact pattern that we're presenting today from very similar to a case that we had. So in the facts, Brian and Cindy have been married for over 8 years. The parties have one healthy 4-year-old child together. The mother has mental health issues, including anxiety, depression, self-harm, and sleeping problems, and has medication in place and psychiatric care apart from the collaborative process. Brian is active duty military and a pilot in the Air Force. Post-Hurricane Michael, his work location at Tyndall Air Force Base sustained so much damage that the squadron moved to Eglin Air Force Base while being rebuilt. The mother was living in Destin, Florida, and the father was living in Niceville, Florida. The mother plans to move to Atlanta, Georgia, near family, and will initially live there with her parents while attending nursing school in an accelerated program. Within 2 to 3 years, her income will likely exceed that of her spouse.
The parties want the best parenting plan for their son, recognizing the importance of having enough quality time to facilitate his attachment with both parents. The parents have property in Pace, Florida, that is a marital property. The father has property in Alaska as well. The marriage ended due to Cindy becoming involved in a same-sex relationship. Both parties want as close to a 50-50 timeshare as possible, and both will require assistance from their parents. The parties are originally from Atlanta, and have much family support there. The parties differ greatly in regard to family values, with one being very traditional and the other departing from that lifestyle. They now have quite different spiritual views.
Equitable division of assets, alimony, time sharing, and the logistics of geographical distance and travel cost are a primary focus. Also, child support, health care, and existing debt have to be addressed. The father can be at any time deployed, which also has to be addressed in the parenting plan. The father plans to depart from military service when his commitment is met, and he believes it will be in the best interest of the child to have both parents residing in the same geographic area. The mental health professional did have to assist the parties in creating the language they were comfortable with regarding exposure of the child when developing future relationships. And the father, in his words, wanted the quote unquote homosexual lifestyle of the mother to have as minimal an impact on the child as possible. So now that we have gone through the fact pattern, what we'd like to do is to transition into some discussion questions. And you've kind of heard that story about Brian and Cindy. So as we go, we'd love to have some lively discussion and interaction with everybody. So we'll move into the first question. Neda?
How to facilitate healthy attachment and quality time with the remaining parent locally due to long distance limitations. That was a big factor that had to be addressed in this case. And some of the ideas that were discussed and incorporated were using Facebook portal, where there is virtual contact between the parent and child, where the computer screen moves about with the child and follows the child, so the child is not stuck to a computer screen. The father will then get to interact with the child in his normal environment and follow him, and they can play and incorporate that in their interaction. Another thing that was recommended was recording stories, favorite storybooks, so that those could be played and the father's voice can be heard, reading the book to the child while he was not available. It was also useful to have that incorporated in case the father deployed, because that would always be possible in this particular case. Other things that are important are FaceTime, having frequent phone contact, incorporating a lot of photos, sharing things of that nature in the house for the child so that they did not feel the other parent was absent. But that made it challenging. And if the child had been even younger, we would have had to have done even more to make sure we did not have difficulties with their attachment. 3 and under, it's always more complicated. And someone else has the next question.
Mhm.
Okay, that's me. So it has some of these have a couple of different parts, and maybe pause in one and see if anyone in the group has any input as well as we go.
Mm-hmm.
What future healthcare options does Cindy have? And what benefits, such as commissary and exchange, which I'm going to define in just a second, will she have access to after the divorce is finalized? So basically, the commissary is the on-base grocery store, for those of you that don't know, and the base exchange for Air Force, that's the on-base department store, maybe called Post Exchange if it's Army. There's just different names, but that's pretty much what they are. So does Cindy qualify for any healthcare options? Well, considering the fact that they've only been married for 8 years, she's not TRICARE eligible, the medical plan for the military, because there are some federal rules that have to be met for her to be able to meet that eligibility. Specifically, the rules center around the number of years of creditable service the service member has, the number of years of marriage, and how much overlap those two have. So the first rule is called the 20-20-20 rule. That's kind of the golden goose. That's the one that's really nice to have, because that's 20 years of at least creditable service, at least 20 years, at least 20 years of marriage, and at least 20 years of overlap between those two. And if they meet that requirement, they get to keep their TRICARE, their medical benefit for life. They also get to keep the commissary on base and exchange privileges for life. And then they do have 90 days after the divorce to actually enroll. So it's not an automatic thing. They need to take action to do that. They do lose that eligibility if they, excuse me, I'll come back to that in a second. Sorry, let me cover the other rule. The 2020-15 rule, similar thing, 20 years of creditable service, 20 years of marriage with a 15-year overlap. There's only 1 year of TRICARE, and they do not get any commissary or exchange privileges along with that. Again, they have 90 days to enroll. If they don't meet either one of those two rules, they have a program called the CHCBP. You know, military loves acronyms, but that's the Continuing Healthcare Coverage Benefit Program. They can be covered up to 36 months. This is like COBRA, but there's certainly some high rates for that as well. But if they remarry or they're covered under an employer plan, then they lose the eligibility for the TRICARE benefits. So, Neda?
Next question that we had was parenting plan caveats with child having to travel for extended periods of time in vehicles or planes if the military reassigns the father to a different base again. And that was a very challenging part of this particular case, simply because the mother did move quite quickly before we were even done finalizing all of the details. She moved back to the Atlanta area and was enrolling in school. But we were fortunate that the parents worked very well together with scheduling, planning, looking ahead, holidays, vacation time. And they did a lot of work in trying to make sure that the parent here got as much time as absolutely possible. That would be quality time with the child. And they also did have to agree on how much time the parents of the party here could also have time with the child, even if the father was not present in Atlanta. And I think in this case, it worked out really well because they were both pretty reasonable. Also, things that needed to be included were ways to entertain this child, because it's quality time in a car when parents are traveling. It doesn't mean sit in front of a computer screen and watch movies. It can be a lot of fun, interacting, playing games, making the trip an adventure so that the child did not dread transitioning. He's a young child and it needed to be fun. But I think in this case, they did very well. And the next question.
All right, back to a financial one. So can Brian's pension, his ultimate pension, be divided since their marriage has been for less than 10 years? Do they actually have to divide Brian's pension, or are there some other options available to them? If they do agree to divide it, how and when would Cindy actually receive her portion of the payment? And are there any other military benefits tied to the pension that might need to be considered? There's an awful lot in that question. So to break it down one piece at a time, can the pension be divided for a marriage less than 10 years? Anybody? Yes or no? The answer is yes, it can. Based on the Uniformed Services Former Spouses Protection Act that was passed in 1982. It does give the states the ability to divide the pension. There's a 10-year myth out there that you have to be married for 10 years to actually be able to divide it. But this is where the 10 years comes into play, to actually, for the former spouse to actually receive a payment of a portion of the retired member's pay directly from DFAS, that's Defense Finance and Accounting Service. Okay, they have to have been married for 10 years. It has to be at least married to the service member for 10 years, and during which time the service member served at least 10 years of creditable service. So there is a 10-10 rule to be able to be paid directly from DFAS. If that 10-10 rule is not met, then they need to come up with some other way for the former spouse to receive those benefits from the military member. The second part, do they have to divide Brian's pension, or is there another option? Well, in short marriages, of course, division, if they do that, there may not be very much there technically in the form of a payment, but they can do what's called a present value and offset. That's actually where the service member keeps all of the rights to their pension, but exchanges and gives up that for another asset. So of course, there's certain information, a lot of information needed to value the pension, but that can be done. If they do agree to divide it, when would Cindy get her portion? She can't receive it until Brian actually retires. She's going to have to wait if and when he actually ever does retire. And that could be a while. And what other benefits need to be considered? If you are aware, you might not be aware, there's a piece called Survivor Benefit Program, otherwise known as SBP. SBP is where the service member actually pays basically an insurance premium. They take a portion of their retired pay, it's deducted, and they pay for that benefit of a survivor benefit, SBP beneficiary, to receive 55% of a base pay they've elected at the service member's death. And there's some key things to know about SBP, and that is, one, there can only be one survivor benefit program beneficiary, only one SBP beneficiary. So there might have been a former spouse from a previous marriage. It's already been awarded that, and you definitely need to find that out. The other thing is that former spouse SBP is not automatic. The former spouse actually has to file what's called a deemed election. There's a form that they have to fill out and submit to DFAS within 1 year of the divorce for that actually to take place. So there's action that needs to be taken for that SBP program to be put in place. Kim, I think you're next.
Yes. And also one more thing regarding the survivorship benefit annuity, the cost of that it comes off the top. So say the military member receives $1,000 a month in benefits, and the payment for the survivorship benefit plan is $100. That $100 is going to come off the top, and then the parties will divide the rest based on whatever percentages they're supposed to receive. If you write it in your order that one party will pay that, it will get kicked back because that's not permitted under the rule. All
Kim,
right.
I did want to answer one question in the chat. It actually had to do with SBP. I'm sorry. The question was, what happens if the person remarries and the eligibility for the SBP? So that eligibility would be suspended if they remarry before age 55. They can regain those benefits eligibility if that subsequent marriage, their spouse passes away or it's annulled or they divorce. So they can have the eligibility, they remarry, they suspend it, and they can come back. So that's the answer to that question. Sorry, thanks.
All right, the next question. Do parents need to revisit the alimony and child support agreement in 3 years as they are anticipating significant changes in financial circumstances of the mother and possibly the father as well? So this is the benefit of collaborative. If these parties were to have litigated, then they would have to come back for any future change in circumstances. But with the handling it collaboratively, a few ideas that we had, and I'd love to hear what all of you think, but is one was to put a provision in there that the parties would come back and collaborate again to readdress those issues in 3 years, because we know that they are going to be that they will have a change of circumstances in 3 years, or just put a tiered plan in place all right now based on what they anticipated that future to be like in 3 years. So put language in that just says, upon the occurrence of these things, this is what will happen. So then they didn't have to come back, or just not say anything at all and allow them to litigate depending on what the future holds. So have any of you did it differently, or Have you dealt with it that in those different ways? Anybody?
Anybody can chime in. Any of the participants.
All right, well, we'll move on to the next one then. The next question is, what are potential consequences if Brian doesn't serve at least 20 years in the military? Well, if Brian doesn't serve in 20 years in the military, then neither of them receive benefits. However, if Brian leaves active duty, you need to be sure to include some provisions in your agreement for if he later joins the reserves. The calculation for acquiring or contributing those days or months that they actually are active in the reserves adds up a little bit differently than active duty. So it will take significantly longer to get to the 20, but it can be done. And so be mindful of that. Also, something a little bit newer with the military members is that a lot of them now have thrift savings plans, kind of like federal employees have. And so it's important to make sure that you find out if the military member, in addition to the pension plan, also has a thrift savings plan. If they have a thrift savings plan, that can be divided and the parties will maintain that benefit even if the member separates before attaining the 20 years. The other thing is if they don't go the full 20, they lose the commissary benefits and all of the exchange benefits and health insurance benefits that David spoke of earlier. Any other input from anybody or questions?
I'll
Oh,
move
I
on.
see. There's some in the chat. At what
Okay,
point
good.
does the service member qualify for retirement? And that would be 20 years. And the SPD, I guess the survivorship benefit plan, that would be the same. You would have to be fully vested in your retirement before your spouse would have that. Well, unless the member died, I guess when no, because the annuity wouldn't kick in until after you retire. So it would be 20 years. And what happens in the parenting plan if he is deployed post-divorce? Is there a makeup time or adjustment in child support? So, and you can really get creative with it and do different things. So I've done where, depending on the length of time that the member was going to be deployed. So if it's a short time, like if it's just like a training assignment where they're only gone for a couple of weeks, then sometimes we don't. I've done it where we don't adjust it. But then I have where members are gone for months at a time, and then we do an adjustment for those months regarding the child support. And it seems like in most of the cases that I've had with military members, both parties seem to be on board with that because they understand, the responsibility left to the non-military member, and they've been pretty receptive to that. Now, the makeup time sharing, sometimes that is helpful. Many of my military families that I work with really want the best for their children. So they understand that upon the military member's return, the child really needs to spend some significant time with them because they've been apart. And so we've been able to add in that makeup time. The only problem is you don't want to put in too much makeup time because then you're going to have a separation issue with the other parent and get the child out of the routine. So, but some makeup time is really good.
So ask questions. So do you put a specific amount of time or do you leave it more open-ended for them to decide? I guess it depends on the relationship if they get along, right?
Yeah, I usually call it the plan B. So I put in that the parties can, determine what type of makeup time sharing the military member will have. However, if they can't agree, then X, I list what that time sharing will be. And then that way they at least have a fallback plan if they cannot agree.
Okay, thank you.
Okay. And address the conversation. What do you recommend to address the conversation of military retired pay into disability benefits?
The conversion of pay into disability, I can address that one if you want.
Go ahead.
Okay. I think Matt Thatcher asked that question. So yeah, disability pay, well, include me and many other military folks might be receiving disability pay as well as their base pay and disability pay. The disability pay is, of course, not taxable to the person receiving it, and that disability pay could actually increase over time if the disability rating of the person actually increases over time. So what happens is, as the disability pay increases, it's offset by a decrease on the base pay on the other side. The disability pay belongs to the military member. That's not divisible. And there's actually a Supreme Court case, was Howell versus Howell in 2017, I believe. It says that judges can't force a service member to make up for that change in pay as the disability pay increases. How you can address that would be, one way to place indemnification language. Of course, the collaborative process, there's agreement, hopefully is the goal to get them to reach agreement, and you're out of court, obviously. But so you place indemnification language in the marital settlement agreement to say, if that occurs, then this is what's going to happen. Somehow will that pay be made up, et cetera, et cetera. That's one way to do it. So hopefully that answers that question.
Okay.
And I did want to say too, and about the TSP that you mentioned, Kim. Sometimes retired folks, and I have come across this, they've worked with the federal government before, and then they came to military, and they might have had reserves in between. So they worked federal service, and they may have a civilian thrift savings plan from that prior employment. Then they come into the reserves and build up a portion of retirement, and then they may go to active duty, and then they have a military thrift savings plan. So there's actually two separate TSPs that you need to be on the lookout for and consider.
Now, regarding the question of how do you avoid parents' attempts to agree to modifying child support or alimony or parenting plan provisions for future events without such agreements being challenged as improper perspective-based determinations. And my opinion would be that because it's an agreement that the parties entered into, it's not something that's ordered, that it would then be enforceable. And can parents look to the future best interests of the child in ways a judge couldn't? And maybe so. But the other thing is that we put in conditions. So it's not like in 3 years, this is what's going to happen. This would be, if X happens, then, this is the plan. So, and then let's see, there's some other questions. How did you talk about dad's hesitation with mom's choice of a same-sex partner, as well as the differences in their values? And Neda, I think that's more you, because you dealt with that more.
Yes, I did. What I ended up having to do was work separately with each party, creating the language each was comfortable with, going back and forth until we could come up with something that both were very comfortable with. So we proposed different ideas and went back and forth, and then I presented those to the attorneys so that what they came to choose would be put in the language that they felt would be best long-term for the final agreement. That did take a little doing.
Multiple drafts.
Yes, it did. Yes.
All right. And then Neda, I think yours is the next question.
Yes. If the child has difficulty with divorce adjustment, can they agree in advance on a course of action they prefer to take? I thought it was very important to consider that in this case because the mother did have mental health issues. So it makes it a lot better ahead of time if parents agree, already have an idea of a counselor or a provider in the area where they both come from, so that they will not delay. If there are adjustment problems, just be in agreement. This is who we're going to use. This is why we're going to use them, and have that all set up, because it just makes it so much easier and better for the child.
And we received another question with, did the parents ever discuss mom's lifestyle choice together? Or was it all done separately? And go ahead, Neda.
That was all done separately because it would have been very difficult to do that together. The mom tended to try to hide her feelings face to face, and in our meetings and debriefings, she always needed more time, and then she would come back to me and then want to address her problems when she could get herself calmed down. So to keep it really amicable, I did keep it separately in this case. It would not have worked that well face to face with both parties.
Okay. All right. Now, when the father separates from the military service, the parenting plan will likely need to be modified. Should a temporary plan be put in place for that now? And in our case, we, instead of waiting for him to separate and doing a final, we just went ahead and did a final order with language in it, allowing them to come back to modify it. And does anybody have any more questions? We've touched on a lot.
And I have one other area to cover, but I'd like to see if we have time. But I want to see if, what questions that any of the participants have, or additional questions, or have we addressed all the questions in the chat for everyone? If we missed anyone, please go ahead and speak up.
Go ahead, Jerry.
I'm Bob may be asking the same question. You folks are up in Panama City and there's a large military base there. What would you, based on some of the questions, and David has identified certain ways in which military pensions are handled, what would you suggest would be a way, a quick study or military divorce for dummies, for us in the collaborative field to learn more about the nuances? I mean, obviously a parenting plan becomes complex because one of the parents may get dislocated or relocated. And I guess my question is, does the military have any guidance for divorce that would be material for us to be aware of?
There's actually a really good book. Let me get it. That I refer to all the time. The author is Mark Sullivan. It's like a military divorce handbook. I don't know if you can see it. And he updates it every now and again, and it is just a wealth of information. So that's usually my first go-to. If you go to DFAS's website, there's also lots and lots and lots of information.
DFAS is, the acronym stands for?
Defense Accounting Finance, is it Service?
Defense Financing and Accounting Service, DFAS.
Yeah. Mm-hmm. So their website has all kinds of information. They have, like if you're drafting the orders, the division orders, they have sample language on there. This book also has sample language, but a lot of cases have some real nuances. But those are where I usually start.
Thanks.
Okay. And I'll put the website, or do you have
it? Go ahead, Kim. No, I was just going to say that the military divorce handbook actually has a third edition that has come out that's now 2 volumes this thick. So versus 1 from before. But yes, it is a great reference book. And you were going to put the website address in?
Yeah, I was just looking it up. It's pretty tricky. So you'll see what I mean when you see it. You can see why it took me a minute.
Yeah, there's
I'm joking.
Robert
Yeah,
Marlin
it's-
has a question.
Okay, go
It
ahead.
does. I don't have a question, I have a comment. This is really informative. I haven't represented anybody in the military in a long time. This is really, really complex. And the biggest message I'm taking from this is that I have no idea what I'm doing in this arena, and there must be experts. That's difficult to do if you're not in the collaborative process, but in the collaborative process, we can bring in the experts to teach us right there. And maybe the other attorney has the expertise and shares it with us, or maybe we're using David because he has so much experience, or a mental health professional who has represented members of the military. I'm like frightened by the amount that I don't know in this arena. So I really appreciate you all doing this. This is a great session from my perspective.
Thanks, Bob.
Thank you. Any, well, the chat's kind of lighting up here. Let's see what that was. If there's any questions that we can address.
There's a question about, do you have a special divorce process for military people? And no, I know that, like myself and a lot of other people in our community, attorneys, they advertise military divorce, but we're not referencing a different divorce process. We're just referencing our knowledge in this area. So because if you have a military member, you definitely need to have somebody on board that, whether either be the attorney or some other expert that you bring on to walk you through it, because there are a lot of pitfalls, like the one David mentioned. So like the survivorship benefit form, I actually fill that out and send that into DFAS for my clients. Certified mail return receipt. I follow up, because there is a great deal of liability with that little form. If you don't do it and your client doesn't know about it, you didn't tell your client about it, and then they lose that. I mean, it could be an incredible amount of money that is lost if they lose that benefit if the member dies. So, Kelly?
There is.
I'm hoping, I know David said that he had some additional information to share with us, but I'm hoping that one of you can kind of walk us through how the division of the retirement actually works. I know it's not a quadro because it's not a qualified plan, but what do we draw? Is it in the judgment of dissolution, or is there a separate order? Where do we send it? Like that kind of the technical part of it.
Mm-hmm.
Sure. Yeah, I can start, or
Go ahead, David.
Add in whoever.
Mhm.
So it's different whether it's a different process, slightly different process if the person's retired or already or not, or they're still on active duty. And also it's different if they're reservist versus an active duty person. But I'll give an example, a couple of examples. If the person's retired already, some important document, a very important document to request is what's called a DD. It's short for Department of Defense, DD 214. That's actually a form that when they're discharged, they leave the military. It has, that's a document you need to get the service dates and so forth off of there. But you need to have that, and it tells a lot about their background and all that sort of stuff. A DD 214 is good to have. And then and yes, you do have, and there is a separate order to fill out or complete and create to send to DFAS, but you need to make sure that the information in the marital settlement agreement is such so that you can create that order to actually make it do what you want to do. In other words, you need to be talking about this and really getting the language correct in the MSA before the MSA is signed, and then you go to do it. It needs to be done. It needs to be happening at the same time is what I'm getting at, and starting that conversation early on as possible so that you collect the documents you need. You've got agreement, because you're addressing, as I said, you're addressing the pension part you're also addressing the potential for survivor benefit program part in the MSA. Another part just to consider is that what happens if the person doesn't stay in, I know Kelly, you asked specifically about the pension division, but if they don't stay 20 years and they go to civil service, work a federal government job, they actually could take the military years that they've accumulated and purchase more into their federal pension. So what happens in the marital settlement agreement, there's a language in there to say if that occurs, then what actually happens? So that's a separate situation from what you asked, but some folks may not be aware that they have the ability to do that.
So David, are you saying that even if there hasn't been 20 years of service during the marriage or 20 years of marriage while the service member was in the service, that the spouse, in the event of a divorce before those 20 years is up, would still be eligible for a portion of that pension, and that you should anticipate either scenario in your agreement?
Okay, I was kind of, there's one scenario is if the person's already retired, then okay, there's a you divide it and there's a way to do that.
Right.
And you need the order. The other is if they're not retired yet, in other words, you're still serving either reserve or active duty, and the divorce is finalized, then you need to, there's a calculation, a very important calculation called the high three. That's the average of the highest 36 months of the person's base pay. Base pay, there's a whole bunch of extra pays that might be in there, but it's their base pay. So you need and when you start the division of the retired pay, you need things like, when did they start in active duty? When was, the date that they entered initial military service or military entrance date? Obviously the date of marriage, the date of filing, the date of the divorce. You need their rank and time in service at the time of the date of the divorce, that high three. All that information is necessary because in 2000, let me see. Let me get my other notes 1 second here. In the end of 2016, the National Defense Authorization Act of 2017 that was signed by President Obama, they changed the definition of disposable retired pay. That's what actually gets divided. That's the person's pay less SPP premiums, less disability pay, less money they owe the government, whatever. So that definition of disposable retired pay is now frozen at the date of the divorce. So what technically happens is the former spouse doesn't benefit from any future increases in the service member's promotion or time in service. So that's why I'm saying it depends on what your scenario is different. So hopefully I'm answering your question. I know that's a lot, but I'm just trying to address it as best I can in this situation. So did I answer your question?
No.
Did I confuse you?
So, I mean, I'm thinking about it. It sounded to me like what you were saying was that that the spouse would have an interest in the retired pay, even if it wasn't the military and any other pension, there'd be a vesting, right? There'd be a point at which that service member is vested. And so, or that employee is vested in the pension.
And that's 20, it's 20 years vesting. It's cliff. You got to get there to receive
Right. So
anything.
if they divorce before the 20 years even gets there, that spouse isn't entitled to anything because there's no.
No, what I was describing was they're entitled to a portion of the marital portion of the retirement has to be figured first. And then, but that their actual benefit of how you write the order is based on their current rank, time in service, and their high three. You need to have all that in the order.
Time in service and high three. Okay.
Yeah, so they are eligible, for a portion of that. And if the order is written and the person hasn't retired yet, but it's frozen right there at the date of the divorce. So yes, they can still receive it, but they won't receive it until the person actually retires and serves their 20 years.
Gotcha. Thank you.
That better?
Somebody just asked about, Betsy just asked about what happens if the spouse dies. So if the beneficiary of the survivorship benefit plan passes before the member does, then those benefits revert back to the member. And yeah, anything else on that, David?
I was just going to say that the service member, of course, would need to make sure they report that to DFAS because they've been paying premiums for that survivor benefit program. So they need to make sure they don't continue doing that if there's no beneficiary.
And I don't know if we touched on this, but when the military member dies, in some cases, many cases, the beneficiary of the survivorship benefit plan ends up getting more each month because they're entitled to, unless the agreement specifies a different amount, they're entitled to 55% of the member's base pay. So, or not base pay, but their retirement benefits. So if it was all split equal before the member died and then the member dies, the non-military member spouse gets a bump up of 5%.
Yeah, otherwise known as a death windfall.
Mm-hmm.
Some people call it that. So if there are any other questions right now, but if we got about 10 minutes left, I've got one other to address about an educational question, but does anyone else, participants, have any other questions for us on what we've covered so far? And Kelly, I hope I didn't muddy the waters too much for you. So.
No, it's a lot of information, but it's all great information. And I agree with what I think it was Jerry and Ed and Bob said, that, you really do need an expert, until you become one yourself. So thank you.
Sure. Can I go ahead and hit the other question? Additional question? We just didn't get it on the list. If Cindy needs financial support because the fact pattern we were talking about that she was going to attend nursing school. So if she needs financial support to attend nursing school, how could Brian potentially assist her with that? So the thoughts around that are the post 9/11 GI Bill benefits. The service member actually has the ability to transfer those benefits to someone else, but know on the front end that those benefits are not actually marital property. In other words, they're not, a court order can't divide those GI Bill benefits. They have to be voluntarily done because those benefits belong to the service member, like the disability pay that I mentioned before. So the parties can agree to a TOE, that's short for transfer of eligibility, and then they can actually have language in the settlement agreement to that effect. But there's some requirements for the person to be able to transfer the benefits. They must have completed at least 6 years of service on the date that their request actually is approved to transfer the eligibility. They must agree to serve at least 4 more years of service. And then the person that they're getting those benefits to must be enrolled in, here's another acronym, DEERS, DEERS. That's Defense Enrollment Eligibility Reporting System. It's just a big database of information. So that person's got to be into the DEERS program or DEERS computer system. So key, again, it's not divisible marital property. It's also a key that this cannot be awarded to an ex-spouse or a former spouse. If they do the transfer of eligibility has got to be done before the divorce is finalized. Has to be. And then there's some different time. Sorry, bear with me a second. Okay, another key. Tried to mute my phone here, but I wasn't very successful. Bear with me a second. I'm sorry.
Timing.
Yeah, perfect timing. 1 second. So sorry, I'm back. But understand that the military member can actually revoke or cancel that transfer of eligibility at any time they want. So there should be some language in the marital settlement agreement for that what if scenario to be able to protect the former spouse or children, whomever that eligibility has been transferred to. So there is a way that Brian can still help her out, but he can pull back on that and change his mind if he chooses to do that. So I just wanted to put that in there as well. That was all I had.
Does anybody have any other questions? I think that's all we have.
Someone, Betty asked the question, so would you put language in so he wouldn't change his mind? You can't keep him from changing his mind. You cannot keep him from revoking the transfer of eligibility, but you can say if they do revoke it, then he or the member somehow makes up for it directly, direct payment or something like that. Just language to make sure that if it does happen, then it's not just out of the blue, and well, it may be out of the blue, but if it does happen, there's protection for the beneficiary it was awarded to.
Preferably contempt provisions so that you can have some teeth maybe, and you can get really creative with that.
So very early on in this discussion, we were talking about some of the parenting plan issues, and I am thinking about restrictions on the mom, who it sounds to me like she was going to be the primary custodial parent, and dad had all these things that he potentially was going to have to do as a military member. Were there any concerns about like where mom could go? Or, I mean, I've had cases like this where somebody's in a job or in the military where they have no control over what's happening to them. And how does that kind of play into the discussions?
In this particular case, it's very unlikely the mother would leave. That was home to the mother. All of her best friends are there. Basically, her entire life seems to revolve around the Atlanta area, and that's where she wants to be. So it's very unlikely that she would choose to locate. It's the harder part really in this scenario is where the father might have to be. But the mother was very much looking forward to being back home. So it's unlikely that she would make a big change in a location of any sort, which was wonderful.
Yeah, especially with the mental health issues, her having that family support was really key.
Yes.
And one thing that we didn't touch on is, transportation. If dad were to get deployed elsewhere, like to Europe or something, and that would really complicate the time sharing. But as a military member, there are some travel benefits, like traveling space, what's called space A, where you basically hop on a flight home and it's terribly cheap, like $10 for the non-military member. But the problem with that is that you have to wait around for a flight. So I've had people wait days for a flight before they can get back to the States. So, and out as well. So when you're drafting your parenting plan, you have to put in language to accommodate that. It can't be the typical, you will exchange the child on this day, because you don't know how long it's going to take. And I had one military case with the military member in Korea. And they had 3 children, and the cost of airfare for all 3 kids to go visit their father was crazy expensive. So they had to do it this other way. And so we had to account for that extra time in the exchange period.
It sounds like flexibility is kind of the word of the day when it comes to these, because you know, these folks don't have a lot of flexibility, right? The military members are doing what they're told to do. And so yeah, it's up to the other spouse, it seems to me, to be flexible and just let the military kind of rule what's going to happen. Is that close?
Very much so, yeah. And that's great with collaborative, because when everybody is working together, it's so much better, you know, because everybody understands that this flexibility is needed. When you're litigating, and I've had some really awful litigation, military cases, and when you have an uncooperative parent, when you're also dealing with these type of issues, is a nightmare.
Right,
Mhm.
for sure.
Especially if the former spouse is, you know, in a military base housing, won't leave. You know, it's a lot of responsibility. The military member's responsible for them while they're on base. So if they do anything wrong, it's a hit against their record, not the non-military member. So they're responsible for whoever's on the base.
Good point.
Mhm.
Other questions? All right, well, if there's nothing else, we're about a minute and a half out, so I guess I will wrap this up. On behalf of the FACP Outreach Committee, we'd like to thank the presenters. You guys did a great job, great information. Thank you for letting us all know how ignorant we are about military divorces. And, you know, if you do one, I guess get the book. Please remember to send us your suggestions for future grand rounds and to register for the January session if you're not already. And enjoy your weekend and happy Thanksgiving to everyone.
Thank you.
Thank you, you too.
Thank you.
Thank you, everybody.